incidences in the process of dispensing justice. Good afternoon to you, Counsel.
Good afternoon.
It's a tough week, I do believe, but we want to first understand what is contempt of court and what makes it a case that is so grave, worthy of 9 months of sentencing in this case.
Contempt of court is any behavior which you may think or the mind of the judicial officer demeans court or disrespects court in any way. And the Constitution is clear that it's one of those cases, it's the only case which is not defined. Other cases like murder are defined, that you kill someone, then intentionally it's murder. So it's to the mind of the sitting judicial officer. So it can range from your phone ringing in court, walking when you're not speaking out loud, or any other things. However, still, it doesn't mean that because it's not defined, it's you should be condemned and heard. You should go through some bit of a hearing for purposes before sentencing you. So it's meant to protect the sanctity of courts. It's meant to protect the decorum of and the respect that the general public give to courts. So that's why it's that sacred.
Okay. In what better manner could this case have been handled, judiciary?
Well, I don't want to prejudice whatever matters, but there are many other ways in which you can stop someone from who you think maybe he's shouting, like they said in the ruling that he was shouting. And of course, the ruling seemed to mix up issues of even what happened in the past, previously. So you couldn't know whether they are punishing him for what happened yesterday or what transpired on 10th December. Of course, they could physically, and many times it happens, they could either order him before even you physically lift, because if before you lift, you must be sure that he has refused to heed the chairman's word in this case. If the chairman had ordered him to go out and then he refuses, then that is contempt. But where they just ask someone, because in any case what preceded it was him being denied access to the bar where the lawyers sit. So there were many other avenues. One of them was to order him, and then if he refuses the order, then that would be contempt. Or to physically lift him, and then there are several other issues. And then if you charge him, you let him defend himself.
Well, yesterday was Aaron Kiza. Previously, we have seen the case of Madema Birizi. He earned up to 1 year in sentence, contempt of court. It begs the question, what are these particular instances reflecting on the law society and judiciary by and large? Is it unruliness of legal practitioners, or there's something in between the lines? Of course, it's a
call for both sides to listen to each other. Usually, if you hear lawyers, because contempt usually used to be for people who don't know the law. If a person who understands the law raises their voice, it means that there's a reason to listen to each other. And then if they cross the line, that's when you can you can mete out a punishment. Why are these people? Because another person would argue that, well, there are many cases that Aaron has handled. How comes he has not been charged? He has never been convicted of contempt of court or charged. So it all goes back to the question of courts. Are we administering justice? In this case, Aaron was convicted by the court-martial. It comes back to the question of civilian trials, the trial of civilians in court-martials. Why don't we settle that question once and for all? So those are things, are pertinent issues, that all these other issues are peripheral. Aaron's, the Dr. Besigye and the other issues, they are peripheral. But the core issue that we've seen all this drama is the trial of civilians in court-martials. Why don't we answer that once and for all? So there's need for courts to listen, there's need for lawyers to listen. They're mindful that there is the law as well, which determines whatever behavior that you should do.
All right, moving forward, what are the presentable remedies that can be used to save Aaron Kiza from serving the 9-month sentence?
This morning, myself, together with over 30 other lawyers, we've had a meeting and we've decided to challenge this conviction and sentencing in courts. So we are also going to meet him for purposes of doing the necessary paperwork. We think that even irrespective of contempt of court, his constitutional rights to a hearing were denied. We know that he was assaulted in the course of the arrest, and even after away from the court premise. So there are remedies, and we are going to seek, put all those issues before the courts of law, and we shall seek to nullify that conviction.
Okay. Counsel Musisi, in closing, where you are standing right now, do you believe that what befell Aaron Kiza is actually fueling the argument that military courts should not be prosecuting civilians?
I entirely agree. I don't think that the reason why army courts, and it was even mentioned very well by the late Justice Kakuri, that in the case of Kabaziguruka, that army courts are well tuned to hear and determine offenses involving soldiers, the military. They are well suited for that. They know that. The people who come before them, if they are soldiers, they know what to do and what to expect. So that question needs to be sorted. The issue of trial of civilians court-martials should be resolved once and for all by the Supreme Court, because the one which has led us here.
All right, thank you so much, Counsel George Musisi, for your insights on this discussion. Of course, here in our NTV newsroom, we're going to be following